Damage. I'm a legal director at TLT, and in this bite-sized session, I'm going to talk through the changes which the new Procurement Act 2023 introduces in respect of contract modifications. So I'm a specialist in public procurement law, having spent almost 11 years acting for public sector bodies, but also suppliers in terms of supporting formal and informal challenges and advising bidders who are participating in complex or high-value procurement processes. So the session today will focus on the 5 topics listed here, namely the rules which contracting authorities must follow in terms of when they can change a public contract and what information they have to publish in the public domain. We're then going to take a look at whether the standstill period is needed before a public contract can be modified and what this means for contractors. And finally, we're going to run through what we believe are the key takeaways in these particular areas. So the starting point is that a change to a public contract is not permitted unless it falls within one of the modification grounds which are set out in the Act. There are 9 grounds which permit a contracting authority to modify a public contract, which are set out on the slide here. If the modification in question doesn't fall within one of those grounds, then the authority is required to undertake a fresh procurement procedure. And if it doesn't, this creates a risk that a procurement challenge could arise. There are grounds which permit the modification of a public contract in the current regime. However, the Act introduces some new grounds which are highlighted in the darker coloured hexagons there on the slide. Just one thing to note, that if you currently have a contract with a public body, the current regime will continue to apply. So the new grounds which this session will cover will not apply to your existing contracts. So you'll need to consider the existing legislation in those circumstances. So just something to bear in mind when you're discussing contract changes with your public sector customers if they predate the enactment of the Procurement Act. So now I'm just going to focus in on 2 of those particular modification grounds where it might be possible for you to do something as a contractor to future-proof the contract to some extent, and that will maximise the likelihood that these grounds can be relied upon in the future. So our advice would be to consider these when you're participating in a procurement process, namely checking if the contract is as future-proofed as it could possibly be. And one of the grounds to think about here is the change is already provided for in the contract. So if the change is already provided for in the contract, there's no need to run a new procurement procedure. You can rely on this modification ground. Note that a standard contract variation procedure wouldn't suffice here. What this ground envisages is that the contract provides a detailed explanation of a change which might take place in the future. For example, if there might be a change to the price or the pricing mechanism, the scope of that change would already be set out in the contract. And usually this would be accompanied by a description of the process that the parties would go through to agree that the change is now invoked. So it does require not a crystal ball gazing, which might be difficult in a lot of scenarios, but of course there are scenarios where it might be possible. And we've started to see contracting authorities starting to do this, for example, including a schedule of future modification options or similar, with the intention that essentially they press go at the time they're ready to draw down those options and rely on this modification ground, or that's the aim. What might be worth noting is that it's not envisaged that the same standard will apply in comparison to the current regime. And you may be familiar that there's a broadly similar modification ground in the current regime. And it does appear that the rules have been relaxed a little bit in the Act, because guidance issued by the government has said that the Act is intended to be less prescriptive, and contracting authorities are now required to unambiguously provide for the modification of the contract, but there's no requirement to be precise and unequivocal, as is the case in the current regime. However, I guess the takeaway point really is it's important to include as much detail as possible in both the contract awarded and the original tender notice, so that it can be described in an unambiguous manner, essentially, and relied upon without the threat of a legal challenge. So the things to look out for would be whether tender documents talk about the possibility of future services being added to the contract in due course. Is this reflected in the drafting of the contract? For example, is there an additional clause or an additional schedule which talks about potential future options and what they look like? If not, you may actually wish to suggest this to the authority. If you're participating in pre-market engagement and you're lucky enough to get a copy of the contract, raise it then, or raise it without a copy of the contract as a potential idea that they could include as part of the procurement process, or even raise it during the clarification period if the procurement process has started, to try and convince the authority that there might be some quick wins here. So the second ground I wanted to focus in on is materialisation of a known risk. And this is a new modification ground in the Procurement Act. So in our view, I think this will be particularly useful for the construction industry. Indeed, the government guidance issued so far uses the example of Roman ruins being discovered, which might require an adaptation to parts of the contract, including timelines and costs. So again, if you think these types of risk might arise if you're successful at obtaining the contract, flag this as early as possible and maybe suggest to the authority that they accommodate the likelihood of this happening in the contract. Now, it might be too late to do this after the tender notice has been issued, because this risk does have to be flagged in the tender notice, but an authority could have the option available to it of republishing or amending the tender notice if it's raised early enough. So it's important to be aware that changes to contracts won't go under the radar in the same way that they do now. The standard position is that authorities will now need to publish a contract change notice on this new central digital platform each and every time that they make a change to the contract, which might sound onerous, but that is the general position. There are some exceptions which are set out on the slide there, but again, it seems that a lot of contract changes will be caught by this publication requirement. So it will be important that the grounds for making the change are justified from a legal perspective and that they are as robust as they possibly can be. Again, this information will go out into the public domain. Otherwise, this might result in a procurement challenge. And again, I'll explain how that would impact a contractor or a supplier a little later on. It's also worth noting that where a modification results in a contract value exceeding £5 million, a copy of the contract as modified or details of that modification, assuming the contract has already been published in full, needs to be published on the central digital platform within 90 days of the modification. Again, there are some certain exceptions which we've set out on the slide there, but it's important, I guess, that the justification again for the changes as robust as possible, again noting that it could be published in the public domain. So you might be familiar with the concept of a standstill period, but probably from the perspective of you've got to the end of the competition and bidders are notified of whether they've been successful or not. However, the Act introduces the concept of a voluntary standstill period, which an authority may observe before it enters into a modification of an existing contract. And the reason why an authority may wish to do this is that observing a standstill period can remove the remedy of set aside. Again, I'll explain a little bit more about that in a moment. But if you see your public sector customers starting to observe voluntary standstill periods before varying a contract in the future, it will probably be for that reason. So you may think, why does a procurement challenge impact a contractor? Well, for the most part, you might be right, as challengers can only pursue a remedy under the Act against contracting authorities. And that has a specific definition in the Act. And it includes essentially central government bodies, local authorities, the public sector. So a challenger can only sue bodies essentially who fall within this definition of a contracting authority. However, there are, of course, ripple effects for contractors where a procurement challenge arises. So if the modification has not yet been entered into, and a claim form has been issued in the High Court during a standstill period, this gives rise to what we call an automatic suspension. And this is a bit like a reverse injunction, which prevents the authority from entering into the modification unless and until the claim is withdrawn, the authority successfully applies to the court to lift the suspension, or the authority is ultimately successful at trial, but noting that it can take on average around 12 months to 18 months for a trial to be heard. So this could cause delays for you as contractors if an automatic suspension is triggered, as you'll not be able to continue with certain aspects of the project because the modification can't be entered into whilst that automatic suspension is in place. In terms of the worst case scenario for a contractor, this is where the court grants a set-aside order. And you might know a set-aside at the moment as being referred to as a declaration of ineffectiveness. And this is essentially what this is. It's a different terminology, essentially. This means that the contract is declared void. So a common misunderstanding is that if set-aside order was granted, the contractor could seek loss of future profits. For example, if you've got any clauses drafted into the contract or you've entered into a side agreement, which we believe will allow for this, our view is that this would likely be viewed as undermining the effect of the set-aside order. So those types of clauses and agreements would likely be unenforceable. However, in granting a set-aside order, the court can make provision for what it calls restitution and other consequential or supplementary matters, which means it may take factors into account, such as allowing payment to be made for services rendered and any other costs which the contractor has already incurred up to a certain point. Sometimes authorities and contractors put in place a side agreement, or it's sometimes called a collateral agreement, setting out what would happen in these circumstances, with the intention that this would be brought to the attention of the court in order to consider those restitution and other consequential or supplementary matters. However, sometimes it can be difficult to articulate exactly what costs will be payable to both the authority and the contractor in these circumstances, but the court, you would have the opportunity to make representations to the court to persuade it to take this into account when determining the scope of the set-aside order, but noting, of course, loss of future profits would not likely be enforceable. I mean, it's certainly something worth thinking about if you believe that a change could be made to a public contract, and the view is that there's a high risk of challenge involved. So considering a collateral agreement or a side agreement to deal with the consequences of a set-aside order is quite a good idea in those circumstances. So finally, I'm going to run through a list of what we believe are the key takeaways for contractors in terms of contract modifications under the new Act. So first of all, check the contract. Going back to the two modification grounds that I discussed earlier, consider whether the contract could be future-proofed and improved as much as possible. For example, if you're aware that certain risks might arise during the project, raise this with the authority. Also think about how the contract might change over time and whether it's possible to include some drafting in the contract now. For example, an option, as we discussed earlier, to purchase add-on services, change pricing, etc., etc., etc. These points could be raised again during pre-market engagement, the procurement process itself, or if you're participating in a multi-stage negotiated procedure, that could form part of your negotiations. Secondly, avoid change as much as you possibly can, and this might require a bit of a change of mindset for certain contractors if your bidding strategy at the moment may be to win the contract first and then worry about what might need to be changed in the contract later down the line, because accommodating changes is likely to be much more difficult for authorities under the Act, given the transparency requirements and the publication requirements. So ideally, you will want to avoid making changes where as much as you possibly can, noting that some may be inevitable, but using the procurement process really to raise any concerns about the contract and make sure it's as future-proof as possible. Next, probe. In light of the risks discussed just now in terms of a set-aside order, You may wish to be a bit more proactive, perhaps going forward, and assist the authority in terms of considering the legal justifications for the change required. I mean, ideally, this should be as robust as possible, given that notice of the change will be published in the public domain, and the stronger and more compelling the argument, the less likely that the modification could be successfully challenged. Some contracting authorities may not always have the budget or the resource to consider these things in depth. Therefore, you might wish to offer some assistance in those circumstances and maybe get your own legal advice. Again, it's up to the contracting authority ultimately what goes into that notice, but certainly you could help along the way potentially. Care should be taken, however, due to the fact that if you do get your own legal advice, that legal advice should be protected by privilege, which means it wouldn't be disclosed in court if it's shared outside of that solicitor-client relationship. So if you are getting your own legal advice and you are working with the authority to build a legal justification for the change, just be careful about how you convey your views and input into that exercise so that you retain that privilege if you've got your own legal advice. Preserving confidentiality, again, considering information could be published in the public domain, be proactive in terms of identifying any information in the contract or the contract change notice, which could be commercially sensitive. And it's always helpful to assist the authority with the justifications for withholding certain information, and usually by referring to an appropriate exemption under the Freedom of Information Act. And a common one we see is Section 43(2) of the Freedom of Information Act, which exempts the disclosure of information which would or would be likely to prejudice your commercial interests. So just want to note there for future reference. Respect and encourage standstill. As described earlier, observing a voluntary standstill period before a contract is modified can remove the remedy of set aside. Therefore, you may wish to support and encourage contracting authorities to invoke a voluntary standstill period. I mean, again, ultimately, it will be a decision for the authority itself whether it wishes to observe a voluntary standstill period. But again, given the potential benefits here, this might be something you wish to raise with them if it appears that at first blush they're not intending to observe a voluntary standstill period. And finally, consider a collateral aside agreement. Where there might be a high risk of successful challenge, you might wish to suggest that the parties enter into this type of agreement, which would set out what would happen in the event the court grants that remedy of set aside. Typically, we see these types of agreements covering issues such as the costs the contractor believes would become due and payable for work up to the date of the order, what happens to any assets purchased for the contract, which barristers are we going to get legal advice from, what's the process if we get that challenge come in. They can be as detailed or as simple depending on the circumstances, but they are quite a useful tool, particularly if it's a difficult project where it might not be easy to essentially unwind the contract if that set aside order is granted. So thank you for listening to this bite-sized session today. If you do have any questions, do not hesitate to contact myself or any of my esteemed colleagues on the slide there. And then finally, just a quick plug about our Procuring 360 initiative, which is TLT's support package for both contracting authorities and public sector suppliers in terms of getting ready for the new Procurement Act. And we are able to offer a wide range of support, not just legal, but also technical, consultancy and more practical support. So do check out our website or contact a member of the team if you require any further support in relation to getting ready for implementation of the new Act. Thank you.